Ever get the feeling that just skimming the headlines doesn't give you the full picture?
Yeah, definitely. It's like you're missing the why behind it all.
Right. And that's what we're all about here, diving deeper. Our listeners are curious, they want to understand the underlying ideas that shape our world.
Absolutely. So today we're putting on our philosopher hats and tackling a big one: international law.
Not just the laws themselves, but the philosophy behind them.
Exactly. We're using the Stanford Encyclopedia of Philosophy's entry on the philosophy of international law to guide us. It's amazing how many brilliant minds have wrestled with these concepts.
So, what's the mission for this deep dive? What are the key things we want to uncover?
Well, we're not aiming to become legal experts overnight. It's more about exploring the fundamental questions. Like, what is international law really? Where does its authority come from? Is it even law in the same way as domestic law?
Big questions, right. And we'll be touching on concepts like natural law, sovereignty, the role of consent between nations, and the very idea of a global rule of law.
All intertwined. It's going to be a fascinating journey. And it might surprise you to know that thinking about how different groups should interact goes way back, even before modern nation states.
Oh, really? I always thought international law was a relatively recent development. Take me back in time. Where do we start?
Ancient Greece and Rome. Thinkers like Plato, Aristotle, Cicero, the Stoics, they were already grappling with these ideas.
Wow, so what were they saying about international law, or at least the ideas that would later form it?
Their big idea was a universal moral code, a right way for communities to interact based on reason.
You mean like there's a right way for humans to treat each other, no matter what city or empire they belong to?
Exactly. This concept of natural law, discoverable through reason, it's still influential today. Think about human rights, for instance.
So natural law is about inherent rights and wrongs, regardless of what any particular ruler or government says.
Yeah, it's a higher law. And this idea carried into the Middle Ages, where Christian beliefs further shaped it.
So those universal moral principles became intertwined with religious doctrine.
In a way, yes. But even then, there were tensions. The Spanish scholastics, for example, used natural law to criticize the conquistadors' brutal treatment of indigenous people.
So even back then, philosophers were using these universal principles to challenge the actions of powerful states.
Precisely. It shows that the tension between universal ideals and state power is not new at all. Now, fast forward a few centuries, and we meet Hugo Grotius, a key figure in the development of international law as we know it.
Okay, set the stage. What was Grotius's big contribution?
He shifted the focus from natural law to what we call positive law.
Positive law. Break that down for me.
It's law that's actually laid down by states through agreements and treaties. Less about abstract moral principles, more concrete rules that nations agree to follow.
Ah, so a move toward a more practical, codified system of international law.
Precisely. And Grotius famously argued that this system would hold even etiam si doremus, even if we assumed God didn't exist.
Wow, so he was trying to create a system of international law that was grounded in reason and agreement, not dependent on specific religious beliefs.
Exactly. A more universal system, applicable to a diverse world. And his work really laid the groundwork for what we see today. Of course, many other philosophers have contributed to the field since then.
Like who?
Well, you've got big names like Pufendorf, Kant, Hegel, Bentham, each with their own take on international law's nature and scope. Then, in the 20th century, we have legal philosophers like Hans Kelsen and H.L.A. Hart adding their analyses.
But the Stanford Encyclopedia entry mentions a period where philosophers seemed less interested in international law. Any idea why that was?
Yeah, it's true that for a while, particularly in the Anglophone world, there wasn't as much philosophical engagement. But toward the end of the 20th century, interest resurged.
What sparked that renewed interest?
Well, partly it was the influence of works like John Rawls' The Law of Peoples, which took a deeply philosophical look at international justice. And prominent international lawyers like Thomas Frank started incorporating more philosophical arguments into their work.
So a kind of reawakening to the philosophical underpinnings of global affairs.
Exactly. And that brings us to the period we're focusing on, the post-World War II era, a time of huge change in the international legal landscape.
With the formation of the UN and all that followed, right?
Right. The aftermath of World War II saw the creation of a more sophisticated international legal structure, primarily through the UN system. And after the Cold War ended, this system expanded rapidly.
Into areas that were once considered purely domestic matters?
Precisely. Things like human rights, migration, environmental protection, they all started falling under the purview of international law.
And that's led to some pushback, right? We're seeing challenges to this international rule-based order from various corners.
Absolutely. The rise of authoritarian powers and populist movements, they often express skepticism about international law, especially in areas like human rights.
They see it as infringing on state sovereignty.
Yeah, that's a key concern. And it all leads to a very fundamental question. Is international law really law in the same way that the laws within a country are?
That's the million-dollar question, isn't it? What are the main arguments against it being real law?
Two big ones.
Mhm.
The lack of a central global enforcer and the role of state consent. Let's start with enforcement. In a domestic legal system, you have police, courts, prisons, mechanisms to ensure compliance. What's the equivalent internationally?
Right, it's not like there's a global police force arresting countries that break the rules.
Exactly. The UN Security Council does have a role in maintaining peace and security, and it can authorize the use of force in certain situations, as we saw during the first Gulf War.
But it's not always effective, right?
Unfortunately, no. There are countless examples where the Security Council either can't act or chooses not to, even in the face of serious violations of international law. And unlike domestic courts, which often have compulsory jurisdiction over individuals, international courts rely heavily on the consent of states to submit to their authority.
So no global police force, no court that every nation has to answer to that does raise doubts about whether international law is truly law in the same way.
It does. Some philosophers have tried to address this by imagining ideal scenarios. For example, Ronald Dworkin proposed this idea of a fantasy international court with compulsory jurisdiction and real enforcement power.
So if we could imagine a system with robust enforcement, maybe international law would be more easily classified as real law.
That's one line of thought. Other philosophers, like Leah Murphy, argue that what matters is whether a system should, in principle, have effective enforcement mechanisms. Then there's the whole idea of decentralized enforcement.
Decentralized enforcement, explain that one.
It's the idea that states themselves can take action against those who violate international norms. Things like sanctions, diplomatic isolation, even reputational damage. A sort of global community pressure.
So instead of as a central enforcer, it's more about states holding each other accountable.
In a way, yes. But what's really interesting is that the dominant view in legal philosophy actually says that coercion, the threat of punishment, isn't a necessary element of law.
Wait, really? So law doesn't have to involve punishment. That's not how I usually think about it.
It might seem counterintuitive, but think about it this way. The primary function of law could be to guide behavior, to provide a framework for cooperation and order. Enforcement is just a backup when that breaks down.
So it's more about having rules and those rules being generally followed rather than the threat of a global cop coming to get you.
Exactly. Hart even made the point that in international relations, violations are often highly visible and carry significant reputational costs, so the need for formal sanctions might be less crucial. Plus, as Louis Henkin, a leading international lawyer, famously said, almost all nations observe almost all principles of international law and almost all of their obligations almost all the time.
That's reassuring to hear, but doesn't that suggest that maybe states are just acting in their own self-interest? Like, they're complying because it benefits them, not because they feel legally bound.
That's the counter-argument, put forth by thinkers like Goldsmith and Posner. They argue that states comply out of self-interest, not a genuine sense of legal obligation. And that takes us straight to the heart of the debate about international law's authority and legitimacy.
Okay, let's move on to the second big challenge. The role of consent. Isn't the basic idea that international law is just what states agree to?
That's a very common view. Article 38 of the International Court of Justice's statute. The authoritative list of sources of international law prominently features treaties and customary international law, both of which seem to rely on state consent. Even philosophers like Dworkin have emphasized consent's central role.
So no treaty signature, no explicit agreement to a custom, no obligation.
It's more nuanced than that. While consent is undeniably crucial for treaties, the Vienna Convention on the Law of Treaties makes that clear there are subtleties. For example, the UN Charter is generally viewed as not allowing unilateral withdrawal. Once a state consents to join, they're bound by this overarching framework.
Makes sense for such a fundamental agreement. But what about customary international law? How does consent work there?
That's where things get tricky for the consent-based explanation. Customary law emerges from a general practice accepted as law, which has two elements. State practice what states actually do, And opinio juris, the belief that this practice is legally obligatory.
Okay, so it's not just about what states do, but also why they do it.
Precisely. Now, a common mistake is to equate opinio juris with state consent. But accepting something as law isn't the same as explicitly consenting to it. The International Court of Justice often recognizes customary rules without needing proof of consent from every single state.
So a practice can become law even if some states haven't specifically said, we agree.
Exactly. Plus, opinio juris isn't about believing a practice is already legally binding. It's about accepting it as law, acting with a sense of legal obligation.
Interesting distinction.
And here's where consent-based theories run into descriptive problems. For instance, how can newly independent states be bound by existing customary rules they never had a chance to consent to? Or how do customary rules change if it's all about prior consent? If states start acting differently, contradicting an old rule, are they breaking the law until enough others join them?
Those are good points. Makes you wonder if something more is going on than just pure state consent.
Right. It suggests that international law's authority might come from something deeper, something that binds even without explicit agreement. As John Teissiulis argues, shaky accounts of custom can actually damage international law's claim to legitimacy.
Okay, so we've poked some holes in the consent theory. But what about H.L.A. Hart's famous critique of international law as primitive law? What did he mean by that?
In the concept of law, Hart argued that while international law has primary rules of obligation, rules about what states can and cannot do, it lacks secondary rules.
Primary rules, secondary rules, what's the difference?
Think of primary rules like the do's and don'ts of international relations, things like the prohibition on the use of force. Secondary rules are rules about these rules.
So like rules about the rule book itself.
Exactly. Hart identified three types. Rules of recognition, which tell you how to identify valid rules. Rules of change, which govern how rules are created, modified, or abolished. And rules of adjudication, which determine how disputes are settled. His big claim was that international law lacks a fundamental rule of recognition, a way to definitively say what's part of the legal system and what isn't.
So without this ultimate rulebook, international law seemed more like a loose set of norms, hence the primitive label.
Yeah, he saw it as resembling a society with basic rules but no complex legal structure. Of course, he acknowledged that primitive wasn't the most accurate term, given the unique context of international relations.
I bet international law scholars weren't too thrilled with that characterization.
Many weren't. They argued that it might just be a difference in how we define a developed legal system. But Hart's critique raised some really important questions about what international law is at its core, questions that are still relevant today.
So has international law evolved since Hart's critique to address these concerns?
Some argue that it has. They point to things like the Vienna Convention on the Law of Treaties, which governs how treaties are made, interpreted, and terminated.
So the Vienna Convention is kind of a rule about rules for treaty making.
Exactly. It sets out procedures and standards, much like contract law regulates agreements within a state. Then there's Article 38 of the ICJ statute, which lists the sources of international law.
Which could be seen as a foundational rule for identifying valid international law.
Precisely. It's more than just about what law the ICJ applies. It's become a key reference point for understanding the sources of international law more broadly. Plus, you have the fact that states can't just freely withdraw from the UN.
Suggesting a deeper commitment, a more constitutional-like structure.
That's one interpretation. These features suggest a more robust framework of secondary rules emerging, even if it's not as developed as in domestic legal systems.
So maybe international law isn't as primitive as Hart suggested, but his critique definitely sparked a lot of important discussion. And of course you have philosophers like Dworkin who challenge the very idea of needing a rule of recognition, right?
Absolutely. Dworkin argued that legal obligations arise through constructive interpretation, where we figure out the underlying moral and political principles that best explain the existing legal materials, treaties, state practice, opinio juris, and so on.
So less about a rigid rulebook, more about interpretation guided by moral principles.
Exactly. And unlike Hart, Dworkin saw law, including international law, as carrying moral force, as being morally binding.
Fascinating. Okay, let's shift gears a bit and talk about states and sovereignty. What does it even mean for a state to be sovereign in the context of international law?
Well, first you need to be a state. Customary international law lays out the criteria. Define territory, permanent population, effective government, capacity to enter into relations with other states, and independence. Sovereignty is closely tied to these criteria.
So sovereignty is like the ultimate authority that comes with being a recognized state.
Precisely. While some use sovereignty and independence interchangeably, James Crawford argued that sovereignty is more about the ultimate authority within a state's territory and on the international stage.
Which traditionally meant absolute authority, right? The state as the final decision maker in all its internal affairs, limited only by its own consent.
That's the classic view, often associated with thinkers like Hobbes. But absolute sovereignty runs into a big problem. It struggles to account for international law, which often binds states even without their explicit case-by-case consent.
So a state can't be both absolutely sovereign and subject to international law.
Not really, no. Think about the UN Charter, with its principles of sovereign equality, peaceful dispute settlement, the prohibition on the use of force. These just don't fit with the idea of states being completely free to do as they please.
Right. That would undermine the whole point of international law.
Exactly. Contemporary international law talks about states having sovereign equality, meaning they have ultimate authority in some areas, but are also bound by international law in their interactions with other states and the global community. It's a balancing act.
So it's about recognizing that states have authority within their borders, but also operate within a larger system of international rules. And it's important to distinguish between sovereignty, which is about legal authority, and power or influence, right?
Absolutely. A small, newly formed state might be fully sovereign, having legal authority, but still lack the economic or political clout to assert itself against more powerful nations. Think of the UK after Brexit. Regaining sovereignty in some areas doesn't necessarily translate to more global power.
Good point. Now, where does the principle of self-determination fit into all of this?
Self-determination. It's enshrined in the UN Charter and other international agreements. It's the right of peoples to freely determine their political status and pursue their own development. It has both external and internal dimensions.
External and internal. What's the difference?
The external dimension is about freedom from colonial rule or foreign occupation. The internal dimension is about having a representative and democratic government.
So international law isn't just about states anymore. It's also about the right of peoples to govern themselves.
Precisely. And this adds a layer of complexity to sovereignty. Self-determination introduces the idea of popular sovereignty at the international level, which can create tension with existing states, especially when a group wants to secede and form its own state.
So the desire of a people for self-governance can potentially challenge the sovereignty of an existing state.
It can, yes. And thinking about sovereignty in relation to self-determination can also link it to individual autonomy, as Timothy Endicott suggests. Sovereignty, understood as the power a community needs to govern itself, can actually be compatible with the legitimate authority of international law, much like an individual's autonomy isn't negated by being subject to their own state's laws.
Interesting perspective. And what about international organizations like the UN, the WTO, the EU? How do they impact sovereignty?
That's a huge question. Centuries ago, Rousseau already wondered how far international federations could go without eroding state sovereignty. Today, we have a vast network of these organizations, both global and regional. And a key trend is that they're increasingly taking on functions that were once exclusive to states.
So decisions that used to be made by national governments are now being made at the international level.
Precisely. And this is at the heart of many current debates about international law, the rise of populism, and what some call authoritarian international law, the selective use or rejection of international norms. Some legal scholars even challenge the separation between domestic and international law, arguing they're part of a single system.
So like blurring the lines between what's national and what's international.
Exactly. But this raises important concerns about individual liberty and democratic self-governance. As international organizations gain power, how do we make sure they don't erode human rights or undermine democracy at the national level?
And the EU is a prime example of this tension, right? It's often described as supranational.
Yes. EU law has a degree of direct effect and supremacy within member states, meaning it can override national law in certain areas. This has fueled debates about whether it's a new form of shared sovereignty or a step toward a post-sovereignist order. Thinkers like Buckenford worried that European integration could challenge the traditional liberal understanding of sovereignty and potentially make it harder for states to serve the common good.
And then there's the idea of a world government, which many philosophers, including Kant, were quite skeptical of.
Absolutely. Kant thought a world government could lead to tyranny and ultimately anarchy. Raz, while also skeptical of a centralized world state, proposed an alternative, relatively sovereign states bound by international regulations in specific areas.
So like a balance between state autonomy and international cooperation.
Exactly. And Rawls, in The Law of Peoples, also explored this balance. He envisioned a society of peoples made up of well-ordered peoples, basically. Societies that are just internally and respect basic human rights.
So not just any state can be part of this society of peoples.
Right? They need to meet certain standards of justice and human rights. And these well-ordered peoples would have a restricted form of sovereignty with a right to non-intervention. Rawls intentionally avoided the term sovereignty in its traditional absolute sense because he associated it with unchecked power.
It all comes back to this question of legitimacy, doesn't it? Why should states or even these well-ordered peoples obey international law?
Legitimacy is the key concept here. And it's important to distinguish between de facto legitimacy, the extent to which international law is actually followed, and de jure legitimacy, whether it has the moral right to demand obedience.
So just because states do comply doesn't mean they have a moral obligation to.
Precisely. De jure legitimacy implies that international law has a genuine right to rule, not just because states happen to follow it out of convenience or fear. But does international law even claim that kind of authority? Much of it is based on agreements, like treaties, and custom arises from state practice, not some global sovereign's decree.
But we've seen how international law is expanding into areas that were once considered purely domestic matters. Doesn't that expansion raise the stakes for its legitimacy?
Absolutely. One theory trying to justify this legitimacy is consent theory. The idea that international law is legitimate because states have consented to it, either explicitly through treaties or implicitly by participating in customary practices.
But we already discussed how relying solely on actual consent runs into problems.
Right. What about norms that bind states even without their consent? Like just cogents, the fundamental non-derogable principles of international law, or customary rules that predate a state's existence. And even if we accept consent as the basis, why should consent be enough, especially if international law serves crucial global goals that need widespread compliance, regardless of individual state preferences? Plus, what about the legitimacy of the consenting governments themselves? Do they truly represent their people?
So a purely consent-based view of legitimacy seems shaky. What are the alternatives?
One is hypothetical consent, often associated with John Rawls. He argued that legitimate international law would be what rational and just peoples would agree to under fair conditions.
So it's about imagining a fair agreement, even if it hasn't actually happened.
Yeah, but Rawls' approach has been criticized for reflecting a somewhat limited liberal perspective and for not being strong enough on human rights.
What about the service conception of authority? How does that apply to international law?
The service conception says an authority is legitimate if following its directives helps those subject to it better comply with reasons that already apply to them. In other words, an authority is legitimate if it makes it easier to do the right thing.
So it's not about whether states agreed to the rules, but whether those rules actually help them achieve better outcomes.
Exactly. Applied to international law, this means a norm is legitimate if it helps states act in accordance with the underlying moral or practical reasons for that norm, like cooperating to prevent war or address climate change.
Sounds good in theory, but how do we reconcile this service provided by international law with state sovereignty?
That's a key tension. The service conception needs to explain how international law's authority is limited to respect state sovereignty. Much himself has suggested that strong state sovereignty might actually be incompatible with strong international human rights law, which is pretty controversial.
And the big question is whether international law, with its limited enforcement and sometimes questionable effectiveness, can actually deliver this service it promises.
Right. De jure legitimacy, under this view, depends on de facto effectiveness. Skeptics like Eric Posner argue that without reliable enforcement, any claim to legitimacy based on service is weak. This is especially problematic in areas like human rights, where direct reciprocal enforcement is difficult.
So if no one's really enforcing human rights law, can it really claim to be legitimate based on its ability to improve outcomes?
That's the challenge. But there are counterarguments. Beth Simmons' work highlights how domestic politics can drive human rights compliance. Others argue that international law offers better solutions to global problems, although whether that justifies practical authority is debated.
We also discussed Dworkin's principle of salience, which relied on his hypothetical ideal international court. Remind me how that fits into the legitimacy discussion.
Dworkin asked what tests this ideal court with real enforcement power should use. He proposed two main obligations for states. First, to enhance political legitimacy within their borders, and second, the principle of salience. This principle says states have a duty to join a detailed and agreed-upon international code of practice if it genuinely improves overall legitimacy. He thought this applies to the UN system, creating an obligation to obey even without explicit individual consent.
But this whole fantasy court idea seems problematic. How can a hypothetical scenario create real-world obligations?
That's the main criticism. Critics argue that Dworkin's focus on an ideal court with enforcement powers gives a too narrow view of legitimacy. They question whether we can derive actual duties from an imaginary scenario. Plus, there's the worry that he's mixing up the existence of law with its moral legitimacy.
Finally, let's touch on democracy. In domestic contexts, we see democracy as a key source of legitimacy. How does that translate to international law?
Two main questions arise. First, should international lawmaking be more democratic? And second, can international law be legitimate for democracies even if they haven't consented to everything?
Good questions. Let's take them one at a time. First, how could international lawmaking become more democratic?
Right now, it's not very democratic. Customary law emerges from state practice, and treaties are negotiated between governments, not directly by the people. Some have suggested ideas like a global legislative body or direct representation of the global population.
Sounds ambitious.
It is. And there's a lot of skepticism. Critics point to the complexities of global civil society and the risk of marginalizing minorities in a global democracy. Some favor alternatives like a fair association of democratic states based on constrained consent. So democratizing international lawmaking is a thorny issue. What about a second question? Can international law be legitimate for democracies even without their explicit consent?
This is super controversial, especially with the growing importance of customary law and jus cogens norms, which can bind states regardless of their treaty obligations. We're seeing pushback, especially from some who argue that such laws can't legitimately bind constitutional democracies without their explicit democratic consent. Even some liberal thinkers argue that domestic democratic endorsement should be a requirement for international law's legitimacy.
So how do we square the binding nature of international law, which often isn't created through democratic processes, with the core principles of democratic self-governance within states? Some respond by saying democracy isn't the only source of legitimacy, pointing back to things like consent theory, the service conception, or Dworkin's principle of salience. Others focus on finding ways to better integrate international law with domestic constitutional processes. Ensuring democratic deliberation when accepting international law could significantly change a state's constitutional framework. It's a tough balance to strike.
Wow, what a journey. We've covered so much ground, from ancient ideas about a universal order to modern debates about sovereignty, consent, and legitimacy. It's clear that these philosophical questions are crucial for understanding global governance and international relations.
Absolutely. By thinking like philosophers, we can go beyond just describing the rules to critically examining their very basis.
So as we wrap up, we leave you, our listener, with a final thought to ponder. The tension between a universal legal order and the enduring importance of state sovereignty, particularly in democratic systems. Where do you think the balance lies? What principles should guide us as we navigate an increasingly interconnected, yet also fragmented world? This deep dive is just the beginning, and we encourage you to keep exploring these fascinating questions. Thanks for joining us.